On to say this: there is no connection between Mr. Kohberger and the victims. There is no explanation for the total lack of DNA evidence from the victims in Mr. Kohberger's apartment, office, home, or vehicle. There is no doubt that this knife sheath will play a pivotal role in the trial. The Gonsalves family attorney, Shannon Gray, previously spoke with Court TV about the importance of the knife sheath on the case. Take a listen.
That was a pretty lengthy probable cause affidavit. It's one of the lengthiest ones I've ever seen. But I think they were very, they wanted to provide as much information as they could to establish probable cause in it. It laid out a little bit of the state's case, how they might proceed on the case at trial. But there's a lot of still other circumstantial evidence that will be gathered between now and the trial date. You still have 3 other crime scenes. You have his apartment, you have the car, you have his parents' house that all need to be processed for evidence of the crime, and then any other evidence that comes in between now and then. But the probable cause, I thought that, it was well done. I think the biggest piece of evidence that jumps out to you is the DNA evidence on the sheet. I think that's the one piece of evidence that will be hard to explain as a defense attorney on the case. So I think that's the biggest piece of evidence.
And Kohberger will be back in court tomorrow for a motions hearing, and Court TV will be there bringing you updates throughout the day. Still with me to discuss, trial attorneys Lateef Gray in California and Kelly Hyman. You're here in studio in Atlanta, Georgia. Kelly, to you first. Your reaction to that response from the defense attorneys? They're really trying.
Yes, absolutely. Well, that's their role, right? You defend your client, you advocate for your client as well. And as we know, the state has the burden. But DNA is pretty strong evidence, especially getting in front of a jury and can place someone at a particular place. It can be very damaging for the defense.
Ding, ding, ding. And Lateef, to talk about that a little bit, when we have these cases now, especially like this one that all eyes are on, the entire nation, if not the world, people want DNA. They want these things that they see on TV, do they not, in these 30-minute crime shows?
They do, but as my colleague said, DNA is very compelling evidence. So if you have DNA in a place where you wouldn't have DNA unless that person was there, it's very compelling. And jurors like compelling evidence, and they like what they see on these TV shows, which oftentimes includes DNA.
Kelly, read between the lines for me on what that legal mumbo-jumbo was about, like we're not getting any information from the state. Do you really think that that's the case? Well,
I hope not, right? The fact that the state is providing, that they have certain obligations and certain evidence that they need, that they're not, for lack of a better word, hiding the ball, holding it back and then waiting to spring on something at the last minute. And so the defendants have an opportunity to look at evidence and do their own, whether it's testing or get experts as well. So I understand defendants want to argue for their client, advocate for their client, but hopefully not. The prosecution is not hiding the ball and giving them everything that they need to bring the case forward.
How unlikely would it be, Lateef, that the defense is actually not receiving discovery in a timely manner?
Well, I've seen prosecutors do that before, so unlikely, I wouldn't say it's unlikely. Prosecutors have an obligation not to conduct what's called trial by ambush, which means that they're supposed to provide all the evidence to the defense in a timely fashion. So I hope that they're doing that in this case, especially since all eyes are on this case nationwide and worldwide.
And where you practice in California, what is the rule for discovery, the timely manner?
You have to disclose it in time for the defendant to use it at trial. So I like to try to get all my evidence from the prosecution prior to the preliminary hearing. But you certainly have to have it in enough time to prepare for trial.
Which is something that we didn't see. We thought that we were going to get all of the cache of information against this guy during a prelim, but they went to the grand jury route.
Right. No, absolutely. You know, that's a really interesting point that you bring up. And so, depending on the state, in a grand jury, the defendants does not bring forth evidence. That it's only the prosecution that lays out the fact, and it's up to the grand jury to make a determination of whether to indict someone or not.
Was that surprising you? In this particular case, I mean, the magnitude of all eyes on this case, did it surprise you that they went grand jury route?
No, I think from the standpoint of to make sure that you cross every T and dot every I, absolutely. And that's what they wanted to do. Because as you said, everyone is watching this case. This is such a high profile case that all eyes are watching. So I'm just assuming that the prosecution want to make sure that they do everything proper and do it the right way so they get the end result.
We're watching it. You at home are watching it, and the families are watching this so closely too, because they want to make sure that they get justice for their loved ones, the 4 beautiful souls that were their lives that were lost. Lateef, recently the judge has ruled that families can now talk. This was something that the Gonzalez family has really been pushing for because they want to be able to share their story.
Yeah, well, when a judge issues a gag order, his or her primary focus is ensuring that the defendant has a fair trial, and he has to balance that with the interests of those involved, which in this case include family members who want to speak out about what happened and want to let the world know that their family member was taken away from them in an improper fashion. So I understand what the judge is doing. He's balancing all the involved parties' interests and making sure that Mr. Kohberger has a fair trial.
All right, we're going to have to leave the discussion there, but none of that matters until we actually have a jury. And you know what they can do? Sequester. Up next, 3 San Antonio police officers are charged with a murder after shooting a woman experiencing a mental health crisis. We have the disturbing body cam video to show you as how it all unfolded. That's next.
I started hearing these stories about murder.
Go deep inside the dark world of true crime.
We knew that what we were doing had consequences, but we just didn't care.
Vice on Court TV, tonight at 7/6 Central.
Tonight on Closing Arguments, Harmony Montgomery's mother, Crystal Sorey, joins us live. Plus, an in-depth look at how the system failed to protect Harmony leading up to her disappearance.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Topping other legal news from across the nation, in Texas we begin. 3 San Antonio police officers are charged with a murder after shooting a woman experiencing a mental health crisis. The whole thing caught on police body camera video. It happened on Friday when the officers responded to a call about a woman suspected of cutting the wires to a fire alarm. When officers confronted Melissa Perez, she ran into her apartment and reportedly threw a glass candle and swung a hammer at the officers. Here's a portion of what happened next. The first gunshots don't appear to hit Perez. Then there are 2 more rounds that are fired. Court TV not playing the whole video, but what we are about to show you is disturbing.
Hold on. You ain't got no warrant. Let's go. Move. Go. Hey, watch out.
The police chief said this: the officers' actions were not consistent with policy and training, and that they were placed themselves in a situation where they used deadly force, which was not reasonable given all of the circumstances. All 3 officers were suspended without pay and then later arrested on a murder warrant. Now to this story. Out of Pennsylvania, jurors will soon decide if the man convicted in the deadliest anti-Semitic attack in U.S. history will be sentenced to death. Opening statements began today in the penalty phase for Robert Bowers, pictured there. Prosecutors called the magnitude of Bowers' crimes staggering. A jury convicted him on June 16th for the killings of 11 worshipers inside the Tree of Life synagogue in Pittsburgh in 2018. The prosecution is asking for the death penalty, calling it a hate crime. The defense attorneys, they claim that Bowers was not driven by religious hate, but by his delusional belief that Jews were committing genocide by helping refugees settle in the United States. The jury must reach a unanimous decision for the death penalty. The suspect accused of killing 5 people and injuring 17 others during an attack at an LGBTQ+ nightclub in Colorado Springs last November has pleaded guilty to 5 counts of first-degree murder and dozens of other charges. 23-year-old Anderson Lee Aldrich, who uses they/them pronouns, will not face a jury trial. Instead, they will serve life in prison without the possibility of parole. Aldrich pleaded guilty to 5 counts of first-degree murder and 46 counts of attempted murder, first degree. They pleaded no contest to 2 charges of bias-motivated crimes. The suspect entered the guilty plea this morning during an arraignment in the El Paso County courtroom. In Florida next, according to new reports, prosecutors need more time before former President Donald Trump can be tried for his classified documents case. Last week, a federal judge set August 14th as a preliminary trial date, but NBC South Florida reports this. The Justice Department has asked to postpone the case until December. Trump is facing 37 criminal counts for mishandling classified documents stored at his residence in Mar-a-Lago. Trump has said that he declassified those documents before leaving the White House. During his arraignment earlier this month, he pleaded not guilty. If convicted, the first 35 counts carry a maximum penalty of 20 years in prison. Still with me to break it all down, trial attorneys Lateef Gray in California, and in studio we have Kelly Hyman. Nice to see you both. Thanks for being with us. Kelly, to you first. So, do you really think that this is even going to go to trial in December? What do you think for former President Trump?
Unfortunately, my crystal ball is broken, but some say I know. Some say that it's going to be after the election that this is going to go to trial. But ultimately, we're going to have to see. So right now, it's supposed to go to trial very soon, and then now it could be moved to December. But there could also be another motion filed to continue. We'll just have to kind of see how that plays out. But ultimately, it will go to trial.
Lateef, I want to talk to you about one of the other stories that we were just talking about, the one out of Colorado, where it was the LGBTQ+ nightclub shooting that left so many injured and others dead. You have the suspect in this case that uses they/them pronouns. They pled today, they pled guilty, but had this gone to trial, would that have helped keep that from being classified as a hate crime, in your opinion?
Probably not. You can be a member of a protected class and still commit a hate crime, meaning I, as a black person, could still commit a hate crime. So I don't think that would have been very persuasive, the fact that he refers to himself with certain pronouns. Given the facts of what happened and how many people were killed, I think that would have been irrelevant. I mean, I think the evidence was so overwhelming that he pled guilty to probably save himself from the death penalty. So I don't think the pronouns he used would have been persuasive had the case gone to trial.
Well, from one case to the other involving multiple casualties and what some consider a hate crime, now to that synagogue shooting and the news out of that today, Kelly. So this is another case where we are possibly facing a death penalty if there's a unanimous decision. Have we moved away from that? Do you think that it is harder to get a death penalty out of a jury, a unanimous decision these days?
I think it depends on the state in which it is. The jury pool, I think it could vary based on the crime and what state it is in. But it is obviously harder because you have to have everyone to agree rather than a majority of people agree to it.
Yeah, fair analysis there. Thank you very much. Still ahead, Scot Peterson. We're going to be talking about that. The former school resource officer charged with not doing enough to stop the Parkland school massacre in 2018. We asked you, and that's today's closing arguments case. We asked what you thought about it all. Your reaction on our social media pages. We're going to share them coming up.
I started hearing these stories about murder.
Go deep inside the dark world of true crime.
We knew that what we were doing had consequences, but we just didn't care.
Vice on Court TV. Next.
Tonight on Closing Arguments, Harmony Montgomery's mother, Crystal Sorey, joins us live. Plus, an in-depth look at how the system failed to protect Harmony leading up to her disappearance.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Hi. You hear the music, you know what time it is. It's time now for today's Talk Back segment. Each day we post a question on Court TV's social media pages where we gather your comments and questions and respond right here on the show. The fate of Scot Peterson rests in the hands of that Florida jury. After closing arguments today, they deliberated for just over an hour and a half before being sent home for the day. Peterson is the former school resource officer charged with not doing enough to stop the Parkland school massacre, that gunman in 2018. So for today's Talk Back, we wanted to know, what did you think of today's closing arguments? Well, here's some of those responses. And you can imagine they were some doozies. Here to discuss, trial attorneys Lateef Gray and Kelly Hyman. You're obviously in California. You're here in studio. Thank you very much. First comment comes from Patty, who writes this. Although the prosecution did an excellent job in their closing arguments in painting the picture of exactly what happened that tragic day, even using Peterson's own words, I am not sure that the jury will have the heart to find him guilty. This is for both of you. Ladies first, what's your reaction? What do you think?
I think that's a really good point. And when we analyze this case, we have to think that usually it's not always a guarantee. The longer the jury takes, the better it is for the defendant. So the fact that they didn't come back right away after the first day could potentially mean that he's going to be found not guilty.
Lateef, what do you think? What is your reaction to that comment from the viewer?
Yeah, I had the same concerns when I, started hearing the evidence that it's obvious that Peterson was derelict in his duties as an officer, but whether that rises to the level of criminal conduct was always a question that I had in my mind of whether a prosecutor could actually prove that this was criminal conduct. So I agree with what the Twitter person said.
All right, let's go to another Twitter person. This comment comes from Sarita. Why ruining this guy's life when it's not his fault? With no bulletproof vest, he would have been another victim dead on the floor. He is not guilty. Lateef, to you first on this one. What do you think about that comment? It was his choice not to wear that bulletproof vest. It was his choice not to bring the other gun. He only had his handgun with him.
And that's obviously things that the prosecutor probably should have pointed out, that he made certain decisions which
they did.
put him in a position where he couldn't respond properly, and because of that, he's guilty of these crimes. Now, whether or not a jury buys it, that's a whole nother question, but that would be an argument for the prosecutor to make.
What argument would you make, Kelly, if you were defending this defendant and he didn't have his vest with him?
That an officer's job is to serve and protect, and just because they don't have the vest on and doesn't mean that they're going to be not diligent in their duties. Just because you don't wear a vest doesn't mean that you're not ready for a fight, so to speak, or protect people.
So that one piece of evidence doesn't prove that that's not the reason why he allegedly did not go in there and stop the gunfire. Next comment coming from Wade writes this: active shooter training is very clear. You immediately run towards the sound of the gunfire to isolate, distract, and neutralize the shooter to save lives. That's the #1 priority. So paraphrasing there. We want to thank everybody for your comments. We don't have time yet for your reaction to that, but I wanted to thank you so much for being in studio with us. Kelly Hyman, you can get her podcast, Once Upon a Crime in Hollywood, and also Lateef Gray, thank you for being with us. Coming up next, we review the 3 things that we have learned today in the cases that we've been covering from coast to coast right here on Court TV. Here are the 3 things that we learned today on a busy Monday. First, the judge sentenced the man convicted of killing an 11-year-old girl and her babysitter to death. But hours before the sentencing, Joseph Zeiler was caught on camera elbowing his attorney to the face. It happened after Zeiler reportedly called his attorney over to speak with him. Deputies immediately took Zeiler to the floor. The attorney was not injured. Number 2, the jury has gone home for the day in the Parkland school cop trial. Jurors deliberated for about an hour and 45 minutes before calling it a day. Scot Peterson is accused of not doing enough to stop Nicholas Cruz from shooting inside Marjorie Stoneman Douglas High School back in 2018, killing 17 people. Peterson has said that he thought that the shots were coming from outside. Jury deliberations resume in the morning. And third, prosecutors have announced that they will seek the death penalty in the Idaho student murders case. Bryan Kohberger is charged in the brutal stabbings of 4 University of Idaho students in their off-campus house last November. Kohberger will be in court tomorrow for a hearing. Court TV will be there. I'm Matt Johnson, in today for Michael Ayala. It's been a pleasure being with you. Up next on Vice, Coyote Brothers human trafficking was